Good morning, Madam Chair and members. We're going to begin with, if we can, with 2590. I think we have some people who have to leave, and so we're going to begin with AB 2590, which is the Restorative Justice Act.
Item 32.
That's item 32.
Okay.
Thank you.
Thank you. I'm here to present AB 2590, a bill dealing with restorative justice. Plagued with overcrowded prisons and recidivism at the unacceptably high rate of 61%, it is obviously time for California to consider effective solutions that help to repair the harm done to victims and communities while creating better opportunities for rehabilitation for those who have committed a crime. Restorative justice programs can be utilized in cases where the defendant is eligible for probation. Participation in restorative justice programs is voluntary, and judges retain discretion to utilize traditional sentences when offenders choose not to participate. In custody, restorative justice programs can also be utilized for those serving a prison sentence. What is restorative justice? Punishment is one form of accountability. Other forms of accountability are accepting responsibility for the harm done and repairing the damage done. Instead of relying solely on punishment, restorative justice provides opportunities for victims to seek redress from offenders and for offenders to accept responsibility, acknowledge harm, and make agreements to repair the damages to the extent possible. Whereas an adversarial system is solely based on punishment that discourages offenders from accepting responsibility and only requires offenders to serve a prescribed prison sentence, restorative justice seeks to bring offenders back into the community by persuading them to embrace the values they transgressed. Nationwide, at least 44 states statutorily provide pretrial diversion alternatives to traditional criminal justice proceedings for persons charged with criminal offenses. Restorative justice has a proven basis in research with more than 100 evaluations from across the U.S. and around the world, including 16 randomized experiments. Results indicate that 1, reduced recidivism in most cases, more than 90% reporting justice was satisfied, and victims report less fear and anger after the program, and families are supported and strengthened. The purpose of AB 2590 is a modest but important step to move California's criminal justice system away from a system which relies solely upon incarceration and punishment and overlooks the needs of victims, communities, and offenders. AB 2590 declares that the purpose of sentencing is public safety, achieved through accountability, rehabilitation, and restorative justice. In addition, AB 2590 encourages the California Department of Corrections and Rehabilitation to provide opportunities for education and rehabilitation to all inmates, not just non-violent felony offenders and those with a short-term left on their sentences. Here to support the bill and co-sponsors PICO, California Catholic Conference, the Industrial Areas Foundation, and Friends Committee on Legislation. To testify today, we have with us Dionne Wilson, who's an advocate for safety and justice, and she is a crime victim survivor. Rita Charez, which is a program coordinator for Healing Hearts, Restorative Hope for those affected by homicide, and she's also a criminal victim survivor. And John Storm, the Director of Restorative Justice for the Diocese of Santa Rosa, and is a retired probation officer.
Good morning, Madam Chair and members. I'm John Storm, and as a probation officer, I wrote approximately 1,000 pre-sentence reports under both determinate and indeterminate sentencing provisions. I also supervised over 1,000 people on diversion, probation, parole, and supervised release over a 35-year career with San Francisco, Contra Costa County, and the federal courts. People need to be held accountable when they harm others and break the law, and punishment must be understood as an important form of accountability, but it's only one form. California's current system, which is focused exclusively on punishment, is seldom efficient, sometimes unfair, and often ineffective. So how do we promote public safety in a way that allows everyone to experience effective freedom and live a healthy and meaningful life? In contrast to punishment being the only consideration, there are sentencing alternatives currently available in only a small number of cases. Those alternatives are more economical, more effective, and more efficient in those appropriate cases. Many of the best are described as restorative justice, a proven strategy that holds people accountable for the harms that they have created and caused and considers the best interests of the victim, the criminal, and the broader community. Sentencing practices that transform lives, transform lawbreakers into law-abiding, productive citizens are far more effective than at promoting public safety than those sentences that rely solely on punishment by imprisonment Further, those offenders and crime survivors who choose to participate in such programs frequently describe them as fairer than traditional practices. Restorative justice is not soft on crime. It actually requires a much more difficult form of accountability than imprisonment, the accountability of admission of wrongdoing and a sincere effort to repair the harms that have been done. I'd like to talk about 3 examples of restorative justice communities within a community. First, let me bring up just the 3 names, and I think they'll be familiar to all of you. First is the Inside Prison Project, which promotes the Vogue Project. I facilitate 2 groups at Pelican Bay State Prison, the first time that's been done at a level 4 institution. I'd also like to recommend to your attention Restorative Resources, a program in Sonoma County, which is highly respected and provides circle accountability groups. And the third is, of course, Homeway Industries, which does not provide classic restorative justice, but provides alternatives to sentencing that transform lives. Thank you.
Good morning, everyone.
Good morning, everyone. My name is Rita Chaitis, and I am the program coordinator for Healing Hearts Restoring Hope for those affected by homicide. I lead support groups outside in my community, and I also work for peace, and I also lead groups, victim offender education groups in prisons. And I personally have been a witness of the transformation that happens when somebody takes accountability and is responsible for crimes such as murder. And I would like you to give 2590 an opportunity, because if we don't give it an opportunity, we won't know if it works or not. And as a survivor of violence, I know what I need. And I need people to take accountability and be responsible. And so I would really, please give this an opportunity.
Thank you very much.
I, Dion Wilson, representing crime survivors for safety and justice, a statewide network of over 6,000 crime survivors, in support of this bill that doesn't make substantive changes to sentencing guidelines at all. It simply brings into alignment the principles of the California Department of Corrections and Rehabilitation, which we've already added to the name, simply brings the philosophy and the penal code into alignment with that and gives victims a say in the process.
Thank you. Are there others in support of the bill?
My name is Jean. I'm a mother of an incest survivor, and I strongly in support of this bill.
Good morning, I'm Pam from Santa Clara, and I also am in support of this bill. Thank you.
Good morning, Madam Chair. Dennis Cuevas Romero with the California Attorneys for Criminal Justice, in strong support.
Good morning, Madam Chair, members. Sarah Linder on behalf of the National Association of Social Workers, in strong support.
Jim Lindberg on behalf of the Friends Committee on Legislation of California, co-sponsor, urge an aye vote.
Linda Warner with the California Catholic Conference, also a co-sponsor in support.
Khalif Asagay, California Public Defenders Association, in strong support.
Good morning, Madam Chair. PICO, California is in support, so White Seal. Thank you.
Alan Eggers, a retired state public defender, and with the Alternatives to Violence Project that does work inside prisons, strongly in support. Thank you.
John Bowders, Californians for Safety and Justice, in support.
Mark Walsh, Civil, Constitutional, and Human Rights Advocate, strongly in support of this bill.
Thank you. Are there any speakers in opposition to the bill? Please come forward if you would make room for them at the table.
Thank you, Madam Chair. Members, Sean Hoffman with the California District Attorneys Association. I want to apologize. I think our letter actually reflected a prior version of the bill. We are still opposed to the bill, perhaps maybe not as vociferously as we were. We appreciate the author, the amendments that were taken in the first House. However, we still have concerns about eliminating punishment as one purpose of our sentencing scheme in California. We certainly believe in accountability, rehabilitation, and for appropriate offenders, restorative justice principles. However, to move from, as the proponent said, a system where all we consider is punishment, to remove punishment entirely from the equation, I think, misses the point. I think punishment is an important factor in enhancing accountability. I think there's a place for it. We're not necessarily opposed to adding things like accountability and rehabilitation into the mission of sentencing and incarceration in California, but we believe that there is an appropriate role for punishment. And we would also, we also take issue with the idea that restorative justice is appropriate for all categories of offenders. I think that when we're talking about, murder, particularly horrific rape, offenses like that, we're uncomfortable with the notion that this would be something that would be broadly applied to everyone regardless of what you've done. So for those reasons, we remain opposed.
Thank you.
John Lovell on behalf of the Association for LA Deputy Sheriffs, California College and University Police Chiefs, California Narcotic Officers, LA County Professional Peace Officers, LA Police Protective League, and the Riverside Sheriffs Association. We remain opposed to the bill, and our issue is very similar to the issue raised by Mr. Hoffman, and that's the absolute deletion of punishment from the equation. To us, a criminal justice system involves strategies to assure that when someone comes out, they're less likely to offend. We supported Senator Vasconcellos' legislation in this area, it seems like decades ago. But punishment is also a part of the equation. Here's what punishment is. It is an implied social contract between the state and the victim that says to the victim, don't take matters into your own hands. We will deliver justice for you. Now, I get to see this and hear about it pretty much every day, as I've shared with this committee. When my wife was 9, 2 members of her family were murdered in what is still LA's worst mass murder, all working class, people of color, victims. And punishment was a part of that equation. And to say we're going to soften this to accountability, you're accountable for burning 6 people to death? No, you should be punished for that first. Let's have strategies so that when you get out, if you get out, you're not going to recidivate. But we think the better balance is the bill as presented by Senator Hancock last week in Assembly Public Safety, which we supported, that adds rehabilitation to the equation in substantive ways, but recognizes that this is a balance. And our issue with the bill right now is that its impact is that the balance is put out of kilter by minimizing the social contract, the implied social contract with victims.
Thank you very much. Are there other speakers in opposition to the bill? Seeing and hearing none, Assemblywoman Weber, would you like to respond to the issues raised by the opposition?
Sure. I think if California has tried the issue of punishment for many, many years, and what we've obviously done is we've created an overcrowded prison system, and a system that as its first effort is punishment, which obviously provides for great opportunity for recidivism, which we've seen over and over again. And it has not in any way made people afraid to commit crime. Punishment does not do that. What we have seen, however, in the various studies that have been done, that when restorative justice is there, when that's a part of the thinking, and it's really a matter of words and thinking, because anyone who goes to prison is going to be punished. The fact that you're taken away from your family, you're taken away from your community, that you're locked up, you're going to be punished. And so, but it's taking a different view of why you're basically being locked up. You're being locked up in order to, one, to provide public safety, to get you away from people that you may harm, but also to bring you back into the fold. and to make sure that we don't find ourselves constantly feeding a system, a prison system that we could no longer afford, not only financially, but in terms of the damage it does to families and communities, and the tremendous impact it has on others in terms of not really providing us with the safety we want, and surely not the society that we want. I think the concept, as we look at it here, keep in mind that this is voluntary. It is not required. And it also has to be agreed to by those who are the victims as well as the perpetrator. So it's not saying that this occurs every time. I know we had some discussion recently of things that happened in San Jose, but the issue of restorative justice would have been that the person who's the victim has to agree to it. It's not something that is imposed without all of the parties participating, because without all of the parties participating, there is no opportunity to provide justice, not only for in terms of helping the person who's the victim, but also making sure that the perpetrator is restored back to society. So I think if we look at it as an option that's available, it is currently being applied in many states and many countries with regards to looking at what is happening in our criminal justice system. California generally has seen itself as being on the forefront, and we've tried everything from determinate sentencing to 3 strikes you're out to hard on crime to you can name it. We have it in terms of being difficult on crime, and all we've done is made an overcrowded prison system and a high level of recidivism. The programs that we've talked about, the research, if you look at it, we had a hearing at the Capitol with all those various programs around the state that are being very effective, reducing sometimes recidivism from 75% down to 15% in some areas in some of our juvenile halls. And so it is really important that we move forward with this. But this is an option. This is not mandatory, it's not required, but it is an option that is available. And we think we will see the kind of results that we claim we want to see in terms of how our prison system really provides a sense of safety and a rehabilitation, and that's one of the reasons why we added that to our corrections department. So I respectfully ask for your aye vote.
Okay, thank you. Are there questions or comments from members of the committee? Senator Stone.
Thank you, Madam Chairwoman. I certainly think that the system should be able to use a menu of remedies for those that are incarcerated, and certainly restorative justice is one of those elements. But frankly, deleting the reference to punishment, I think, is a mistake. I think our society has certain values, and there has to be consequences to crime. And I don't think we should use the excuse that just because our jails are overcrowded, that we shouldn't be punishing people the likes of Lawrence Bittaker, commonly known as the Toolbox Killer, who kidnapped and murdered 5 teenage girls in Southern California in 1979. I think if the family of the victims were here today and were asked, would you want to see punishment continued against the perpetrators of that crime, I would opine that they would say yes. So I'm not saying that punishment is solely the issue that should be focused on as part of our rehabilitation system, but to delete it, I think, is really a mockery of our judicial incarceration system here in the state of California. And for those reasons, I cannot support it.
Okay, thank you. No, I'm sorry. We can't really do this. We have too many bills and everybody testified. I think it's basically a committee discussion at this point. I have to say, this brings back to me so strongly the experience that Senator Liu had, that I've had, of going to Norway and visiting Halden Prison, something I would really recommend because the prison system there is focused in such a different way. What they say there is punishment, the punishment is the loss of freedom. Mm-hmm. The conditions of confinement should not be the punishment. And unfortunately, because punishment was the only thing listed in our mission for our penal code for so long, the conditions of confinement became the punishment. And as you all know, we've had some horrendous examples, both in our county jail system and in our prison system, of what I can only call human rights abuses that have no place in this country or any place on earth, really. So I really thank the author for bringing this forward, because I think as long prisons and jails have the concept of punishment inherent in them, But also, I'm very impressed with the idea of restorative justice. I don't think that is in my version of the bill. I've seen it operate in high schools in my district where the expulsion rate is drops by like 2/3 in 1 year. And it does have to be agreed to by both the victim and the perpetrator, and it has to be rigorous. It can't be, oh, I'm sorry. It is rigorous, and it revolves restoration of what the victim needs, whether it's financial, psychological, or whatever, to be made whole, right? And I've also visited a number of the groups that were referenced in state prisons, and they do extraordinary work in terms of getting individuals to accept accountability for what they did and begin to look forward, since most of them will be returning to what they need to do to return as safe neighbors to their communities. So I will be supporting this bill today. I understand the reaction to removing punishment. Something can be discussed as we go along. But I do think that this bill raises some very important positive directions for California's future. Thank you, Senator Liu. I don't know if there are any other questions or comments, or if you'd like to close.
I just respectfully ask for your aye vote. I think it's a major step for California as we talk about changing what we do and being better and providing safer communities.
Okay, thank you. Please read the roll.
Hancock?
Aye.
Hancock, aye. Anderson?
No.
Anderson, no. Glazer?
Aye.
Glazer, aye. Leno?
Aye.
Leno, aye. Liu? Liu, aye. Monning?
Aye.
Monning, aye. Stone?
No.
Stone, no.
That bill passes. Thank you. So, Assemblywoman Weber, would you like to do item 8 or item 35?
AB 1761, what is that? Number 8, okay. I don't know the numbers. This is the Human Trafficking Victims Affirmative Defense, AB 1761. Currently, human trafficking victims are treated as criminals with respect to the crimes that traffickers force them to commit. Human trafficking is a unique crime in that traffickers often benefit from having their victims commit illegal acts and may force both children and adults to commit a diverse range of crimes. Traffickers reinforce their power and control over victims by instilling fear of law enforcement and the systems designed to protect victims. So the victims, both adults and children, often initially lie to law enforcement about the circumstances of their trafficking experience or proactively attempt to protect the traffickers. Other affirmative defenses, such as the defense of distress, do not reflect the lived experiences of many victims of sex trafficking, whose relationships with their traffickers are characterized by coercive control rather than direct threats of imminent physical harm and are therefore limited in their usefulness. Once trafficked, children and adults endure repeated violence and rape, not only at the hands of their traffickers, but also from countless buyers who pay to rape and violate them. Compounding that trauma with the added trauma of arrest and prosecution is unconscionable. It leaves victims further traumatized and often with a conviction of juvenile record that impedes their ability to access future education or job opportunities. The field is recognizing the detrimental effect of criminalization on this population and moving away from the approach in favor of treatment and alternatives to arrest and detention. We want to protect victims. Arresting them often does not do that. Arresting them often harms them by involving victims in a system built on punishment. AB 1761 offers a new tool for victims of human trafficking to use to protect themselves against further harm and begin the healing process. Specifically, this bill creates a defense for human trafficking victims to use against a charge of a nonviolent crime. This affirmative defense is not a get-out-of-jail-free card. It has to be proven by the defense in the court of law that the victim indeed committed the crime because they were a victim of human trafficking at the time of the offense, that they were coerced, and they had a reasonable fear of harm. This bill is sponsored by the Coalition to Abolish Slavery and Trafficking and the National Council of Jewish Women. Witnesses here to testify in support of this bill is Stephanie Richards, who's representing the Coalition to Abolish Slavery and Trafficking, and Rafael Bautista, a survivor advocate, and Monica Anderson, a survivor advocate.
Thank you. And we do have two minutes each. If you take less than that, you can.
Yeah, I'll be quick. So my name is Stephanie Richard. I'm the Policy and Legal Services Director at the Coalition to Abolish Slavery and Trafficking. And I'm here today to ask you to support AB 1761. CAST does not support legislation in the anti-trafficking movement that we don't think will impact victims on the ground. And unfortunately, the criminalization of trafficking victims for crimes their traffickers force them to commit is prevalent in all of the clients we serve. And once they're convicted of these crimes, then they cannot recover from their trafficking experience. They cannot rent apartments in their own names, or they cannot find safe housing. They cannot get employment, and so it keeps the cycle of abuse going. And so because of the very specific nature of this crime, it's important that we establish this new affirmative defense so that they are not open to exploitation longer, and that perpetrators and information about the traffickers that are the real exploiters come forward. And so we want to encourage our public defenders to be looking at these individuals' crimes and finding out if they're trafficking victims so that the real information comes forward. And I'm going to turn it over to Rafael, who will speak from a survivor's perspective first.
Good morning, everyone. My name is Rafael Bautista. Thank you for the opportunity to speak with you today in support with AB 1761, Affirmative Defense of Human Trafficking Victims. My name is Rafael Bautista, and as a human trafficking survivor, specifically for labor trafficking, my trafficker first hired me to do office work. I have been doing restaurant and washing dishes work at the time. So moving up to an office job seems like an American dream for me. The man who trafficked me first seemed like an angel, but he was fake. When I began working for him, he had me move into his house, telling me that I will save rent money. But shortly after I moved in, he stopped paying me. He completely stopped paying me. In addition to the office work, he forced me to clean the house, cook, wash the dishes, do the backyard, and drive him around. He threatened me to kill me, and if I did not do what he said. He also threatened to harm my loved ones and to have me deported because of my legal status at the time. I suffered this abuse for 2 years. I stand here today representing not just myself as a survivor of human trafficking, but as a survivor leader of human trafficking in our local Sacramento group. In leading this group, I have worked with many other survivors like myself, and I want to share a story of one of these members. This man was forced to work in a ranch in a remote location. The traffickers stole cars and took them to that ranch and make the survivor break the cars apart for sale. When this was discovered by the police, the survivor and his trafficker were arrested and convicted of stealing cars. The survivor was too scared to tell the police at the time. He was arrested. He was also never asked questions by his public defender or anyone. After serving some time in jail, he was released, never understand or know what was the problem at the time. AB 1761 is an important piece of legislation as it will protect both sex and labor trafficking survivors from being convicted of a crime that the traffickers forced them to commit. I hope you will support survivors today with your vote. Thank you.
Thank you for the opportunity to speak with you today. My name is Annika Mack. I am a survivor of domestic human trafficking. When I was 18, I was targeted for trafficking in the life of prostitution. I was trafficked for 4.5 months. I was kept against my will completely by physical force and fear. I was forced to work every night and was sold to 4 to 6 men per day. Every date lasted 30 minutes. I was forced to make a quota each night. During the first month, my quota was $750. For the remaining of my trafficking, my nightly quota was $1,750. I was paid by cash for the men that bought me and had to give the money to my traffickers. I escaped my trafficking when I was dropped off near a hospital, nearly dead. I spent a month recovering from the physical abuse of my trafficking. I was never arrested when I was trafficked. I was picked up by police, but was released after questioning. The police officer did not have enough evidence to arrest me or the girl I was trafficked with. I was scared to tell the police what was happening because because of the repercussions of my trafficker, and I was afraid to be arrested. I know many survivors who were arrested. One trafficking survivor was arrested multiple times by the same officer and was falsely identified each time. She was scared to tell the police what had happened to her as well. I support AB 1761 because I think it will help many victims be identified earlier.
Thank you. Thank you very much, especially the two of you for coming forward. It means a lot to us to hear your stories. Are there witnesses, other witnesses in support?
Good morning. I'm Claire Lipschultz with the National Council of Jewish Women, a proud co-sponsor of this bill, and we urge your support.
Good morning, survivor of sex trafficking as a child, and I support this.
Good morning, Danielle Molay with the California Alliance of Child and Family Services in support.
Good morning, Neha Desai with the National Center for Youth Law in support.
Madam Chair, members, Khalif Ostergai, California Public Defenders Association, in strong support.
Micah Doctoroff on behalf of the ACLU of California in support.
Jody Langs, West Coast Children's Clinic in support.
Okay. Others in support? Seeing and hearing none, are there speakers in opposition to the bill? Please come forward and please make room for them at the desk.
Good morning, Madam Chair. Ruann Dozier with the District Attorney's Office here in Sacramento. First of all, we want to thank the author's office for working with us and talking with us throughout this process. We do not oppose the portions of the bill that relate to the duress defense, the affirmative duress defense, nor do we oppose the portion of the bill that deals with allowing for expert testimony. Our opposition surrounds the sealing of the records. Now, staff has indicated that they will be working with us on amendments. But I just wanted to make it very clear to the committee what our concerns were, because it will actually relate to another bill that's on the agenda, 1762. So 1761 uses the factual innocence statute. That is a different animal, meaning under the law, when somebody is factually innocent, it's because they didn't commit the offense. The elements could not be met. And so the person is factually innocent. And so those records are sealed because it never happened. The crime never occurred. In this case, we're dealing with the crime occurred, the non-serious, non-violent crime. However, the law is providing an excuse, a legal excuse, why it was okay that it was committed. So the sealing portion needs to be changed for that reason. In addition, by sealing the records and not allowing the prosecution at any point in time, not giving us a window of time to obtain those police reports, our ability to prosecute the traffickers are actually deeply affected. When we are prosecuting a trafficker, we look to prior victims, whether it be in our county or throughout the state, so that we can build in our prosecution case a pattern of conduct, and we can actually reach out to those victims and have them testify if the applicable rules apply for establishing a pattern. So we just wanted to state that we're hoping that we can work with the author's office and so that we will be able to access those records to help us and benefit us when prosecuting a trafficker.
Thank you.
Good morning, Madam Chair. Sean Hoffman with the California District Attorneys Association. In the interest of time, I will affiliate my comments with those of my colleague, except to point out that there is an existing duress defense in existing law. We believe that this unnecessarily waters that down for a select group of offenders, and for that reason, we are opposed.
Okay, thank you. Are there questions or comments from committee members? Senator Glazer.
Thank you, Madam Chair. I wanted to thank the author for bringing this bill forward. I'm pleased that through the amendments that you've taken, you've been able to work with the District Attorney of Alameda County in my district, and based on that, I'm happy to support the bill today.
Would you like to move the bill? I'd be happy to move the bill. Bill's been moved. Any other comments or questions? would you like to close?
Yes, Madam Chair and members, we do plan to address the opposition's argument with regards to the sealing of the records, and so that will be handled at the next committee. But by creating a new affirmative defense, traffickers, we're recognizing the traumatic effect of the emotional, mental, and physical abuse trafficking victims endure at the hands of their traffickers. We're also joining 34 other states that have an affirmative defense for this particular on their statutes, and so we're very proud of that and respectfully ask for your aye vote for 1761.
Thank you. So the bill has been moved. Thank you for agreeing to work with the opposition on fine-tuning it, and I'll be supporting it today as well. Please read the roll.
Hancock.
Aye.
Hancock, aye. Anderson. Anderson.
Aye.
Anderson, aye. Glazer.
Aye.
Glazer, aye. Leno.
Aye.
Leno, aye. Lou.
Aye.
Lou, aye. Monning.
Aye.
Monning, aye. Stone.